Welcome to the Vicca Law podcast, Protecting Legacies, Resolving Conflicts. I'm Lidia Vicca, Director of Vicca Law, where we specialise in succession law, civil disputes and litigation in Queensland. If you want to safeguard your assets, navigate estate planning with confidence, or resolve legal conflicts effectively, you're in the right place. Join me each week as we break down complex legal issues into clear, practical insights, helping you protect your legacy and find solutions with certainty. Let's dive in. Hello and welcome back to the Vicca Law podcast, Protecting Legacies, Resolving Conflicts. I am your host, Lidia Vicca, Director of Vicca Law, and we are continuing our August theme of probate and letters of administration. And this week, we're going to talk about what to do if there's a problem with the will or something within the will and how that might affect your application for probate. So last week we discussed what is probate, when it is needed, and essentially probate is an application to the court that this is the original valid last will of the deceased, and it's an order called a common form order whereby the court authorises that the will is valid and that the executor has the authority to administer the will. So what do we do if there's a problem with the will? Now, this has occurred for me in practice, not that often to be fair, but on occasion it will happen. So the things that you need in a will for a valid will and a will to be able to apply for probate, the first thing is that it needs to be the original will. Okay, so it needs to be the actual original signed version. That's why it's so incredibly important that you know where your original will is and you're able to access a copy. Okay. I have lots of people that come and say, oh, I did a will 20 years ago with a solicitor. That solicitor has now closed. I have no idea where the will is. Now, my understanding from understanding my obligations with the Queensland Law Society is that if I was to close or if I was to move my safe custody, I'm required to notify the Law Society, but also offer all the safe custody that I hold, because I hold original wills after I do them as part of my estate planning service. I am required to offer those safe custody back or offer them to be transferred to someone else. That's my understanding. But the reality is, quite frankly, that lots of people come to me and say, I've got no idea where the original will is. And we go on a bit of a mission to find it, okay? So you need the original will. It needs to be dated, and it also needs to be witnessed and signed and witnessed by two independent persons. So the person can't be beneficiaries of the will. Okay. That's all that is required for a valid will. Oh, sorry. There's a few other things. I always do that, don't I? Jump the gun. Okay. You also need to appoint executors and you also need to be gifting in your will. So there needs to be some gifting that occurs, some administration of the estate. Okay. So those are the things you need. But really if you have all those bits in between the executors, the gifts, it really needs to be signed, witnessed, and dated. Okay. Now, there are lots of ways in which a will can be stuffed up. Handmade wills, home wills, DIY wills, there's quite a lot of stuff up. So the ones that you will often see is some kind of marking on the will. So you're not allowed to mark a will after you've made it. If it has been stapled, it should not be unstapled and restapled. It should not be teared. Those are all things that may indicate to the court that this will is not the original will, or it has been amended, or something is wrong with it. If you are going to try to remove or delete something in the will, you are able to do it, and there are mechanisms to do it. And I recently looked at this for a client. But really what we say to people is if you're taking the original will, don't damage it in any way. Don't make it seem like it has been amended, because when people think about an unstapling and restapling, that could be problematic, because what if a page is missing, for example? Now, these things are not completely detrimental to your application, but they do make it more difficult and annoying for me as a solicitor, okay? So if there is a problem with it, so if there's holes in it, if there's some kind of damage, you need to do an affidavit of plight, the executor, to give a reason why the damage existed. So a really common one that you'll do is that the executor didn't know that you could you couldn't unstaple and scan the will, usually to send it to me, and then they've restapled it, that's a way to do it. If the will doesn't properly contain the clause that's required at the end of the will to say that it's their last will and the date and these are the witnesses, a witness can do an affidavit to explain that. If it's not properly dated. So I had a will a couple of years ago. It was a will, I think it was like 35 years old, and it had been dated on the front of the will, like a cover page, but it wasn't dated on the back where everyone signed. And we actually were able to track down the solicitor who took the will, and he confirmed that the date on the front was the date that the will was witnessed, which was actually really cool to do. But those are all kinds of reasons why there might be problems with the will and how you overcome it. And it's really your ability to show the court and the registrar in particular for a common form grant that these things can be explained and someone's able to swear to it. Okay. Now, if there are things that cannot be explained, if you only have a copy of the will, if it's not properly witnessed, these issues can all be overcome, but they need an application to the court and you need to provide very good reasons. And there's ways under the Succession Act and the UCPR, which is the Uniform Civil Procedure Rules 1999, that you can do that. But it does add a level of complication. It's not a standard probate. Okay. And then, of course, the other reason that you might have a difference in a will is where the executors named in the will have either renounced or they are just simply unavailable. Now, renouncing means that they don't want to do the executorship. And we'll find that occurs generally, in my experience, I've had it occur where the surviving spouse is quite elderly and just doesn't want the role or doesn't have the capacity. Capacity is one of a reason where someone might renounce their role as executor, or the person that was executor may have predeceased the deceased person and they're no longer available. Okay, so depending on how the will is written, you could go forth with the alternate executor, and in that circumstance, the person applying the alternate needs to explain why that first person isn't available. So a renunciation, which you also file with the court if they died, a death certificate. But if there's no executor in the will, then it actually turns into a letters of administration with a will. So you're applying to the court as the person with highest priority to the estate to administer the estate, to administer it in accordance with the will. You're just not the named executor. Okay. And those are the most common things that I will see. Now, the best way to kind of prevent all these ways in which your will can have some issues after you pass away is to do the will with a solicitor, because we are obviously trained, we do these day in, day out, and we know how they are to be written, how they are to be executed, and also how they are to be stored so that there are no problems at a later date. I will quite often see wills where people haven't updated their executors, and that has been a problem as well. And so it's really a good idea to go through a solicitor. All the circumstances can happen and really prepare for circumstances that you may not know of. You know, what I say to people when I do a will is, if you never look at this in 30 years, I want it to be solid. I want it to have no problems and we've accounted for any scenarios. But, you know, you should update your will just quietly. But I also really do kind of prepare people that this could be their final will. And that's knowledge that you'll only get from a solicitor. So if you have any questions about your will, or if you have questions about somebody's will, I recently had a couple come in where they had done a lot of notes on their will and we had a discussion about whether it would be appropriate for probate or not. So that kind of discussion, we can definitely do that. You can book a free consultation on my website, www.vicalaw.com.au, and we can have a chat. I hope that wasn't too much information. I feel like I've just spat it all out in one podcast. But I really do can I like probate? I guess I just like helping people. You know, when you do a will, I think it's really your final direction. And one of my friends actually, Chris, if you're listening to this, said she thinks it's the final act of parenting that you have when you do a final will if you have kids. And it is really true. And I am of the view that if somebody has gone to a solicitor, gotten advice, and done a will, then that will should be followed. And probate is really the first step of that. So thanks again for listening. Next week, we are going to be talking about dying intestate and what that means in terms of letter of administration and what you need to do as a loved one, because that is really hard for people when they've had a circumstance where someone they love has died without a will. And I definitely do not recommend it in any way. So thank you so much for listening, and I will speak to you next week. Bye. That's a wrap for this episode of the Vicca Law Podcast, Protecting Legacies, Resolving Conflicts. I hope you found today's insights helpful in navigating your legal journey. If you're ready to take the next step in securing your legacy or finally dealing with your dispute, you can pop on my website, www.viccalaw.com.au, to book a free consultation with me, Lidia Vicca. You can also subscribe to our newsletter or find out more about today's topic. Your future begins now, and we're here to guide you every step of the way. Until next time, I'm Lidia Vicca, signing off. The Vicca podcast comprises general information and does not serve as a substitute for professional advice. Prior to making any legal decisions, individuals are advised to seek independent professional guidance and assess the suitability of this information for their own individual goals and objectives.